Good morning. Welcome to our March public hearing. We had 4 speakers endorsed. I believe 3 are here so far, so we will proceed. Oh, no, 4. Angela's here. Judge Sherrigan's here. Welcome. We have all 4 speakers here. I think most of you have done this before, so you know our rules are 3 minutes. Obviously, if we have more questions, it could go on longer. We have special rules for Mr. Olsman, 30 seconds. We'll start with item number 3, which is the lawyer advertising rule. Mr. Olsman.
Good morning to all of you. May it please the court. Here we are back again on Rule 7.2. But the proposed rule, as the court sent it out on September 27th, 2018, seems to fit the bill, with the exception that I would request that the terms icon and image be added to that rule following the words web address. And I say that because of the type of advertising that's out there where there is no name, there is no number, there is no nothing, candidly. We're back to the whole issue of protecting the whole issue here is to protect the public, make sure if somebody calls a number or goes to a website that they're assured that the person that they're talking to is in fact an attorney, that it's real, and that their interests are going to be protected here.
Mr. Olsman, do you object at all if that information is on the website and not necessarily on the advertising itself?
No, in fact, Justice, the comments that were made by 3 of the people who wrote in talk about this Google click business, and I'm too old to know what that is, so I had to spend some time figuring it out. And in fairness, this has been part of a collaborative effort involving myself, Dan Quick, Professor Sedler, Ken Mogill, a number of people. This is above my pay grade, candidly.
That's supposed to make us feel better.
Well, no, but the argument there is one reasonable statement that could be made about that, is that the Google click isn't the ad. The Google click is the portal to get into the ad. And as long as, we're back to the same point, as long as the ad says who the lawyers are that will be providing the services, fine, do whatever you want. But to advertise with complete anonymity, public services that the public, people are going to for serious personal matters, whether it's financial, whatever it may be, there should be some assurance that the person that's going to do it is competent, competent is a more subjective point, but minimally is a lawyer.
But it sounds like you don't object as long as that information is on the website when somebody goes to the website.
Absolutely fine.
Okay.
And when we were here last summer, that came up with respect to my colleague, Mr. Kresh, who has the 1-800 law firm building. And I said, if you Google 1-800 law firm, you go right to their website. You can see every person that works there and what they do in that business. I mean, that's fine.
Fair to say you're just trying to pick up the worst offenders?
Another way to say it would be, if you look at it in a vacuum, you could say, and this was Mr. Mogill's point, well, it's a small amount, it's a small number. It doesn't, and I don't even know that you have to say worst offenders. I think we have the right to regulate it.
By that I mean the people that it's really hard to find out who's behind.
Yes.
Who's behind the.
Sure. And unfortunately, the fact that those kind of entities exist, or case brokering services, or people that aren't lawyers, that if you call them and say who's there, we don't know, and I mean, we can't tell you, that kind of stuff. This is serious business. And when I was here back, I think it was in June of last year, Justice Markman raised the point about, well, maybe we should just wait and see what the ABA does. And, I'm like, okay, well, I'm not going to tell you don't do that, but I don't think that, I just see what we have here as being pretty close to what we had before, which is fine. But Janet Welch was here and she heard the argument and she said, the better argument is we're officers of the court. We don't sell plumbing supplies. We're not selling hardware. We're officers of the court. I mean, there's got to be some standard to which you can be held. I did see one of the comments one of the commentators, the person that wrote in, talked about analogizing this to a political campaign. And not that I would understand Citizens United, but Professor Sedler indicated that in Citizens United, they don't say that all speech can't be regulated. They said that Congress has the right to regulate political speech and things like that. Like if you had a button and it said Jules for Judge, and it just didn't say paid for by the committee to elect Jules for Judge, well, that's okay, but Congress reserves the right to regulate that.
Let me ask you one question, because you're out of time, but
Yeah.
if you want to add two words, icon and image.
Correct.
I'm looking at my handy dictionary.com definition of icon, and the first definition is a picture, image, or other representation. So
Then
do you
the
have a
word
view of
Image, the word
Does it add
singular
anything?
word image is fine. I just look for all the ways.
icon? Icon would be the broader term, I think.
I just look for the way somebody's going to say that doesn't include me, or that isn't what I did. I'm just looking for, I know my colleagues, somebody's going to say, well, that's a sketch, it's not a picture or something like that. That's fine. I think the court knows exactly what we're aiming at here with regard to this. So, based on all the commentary and based on what was said here back in June, I don't think there's much disagreement about this, and I think that the notion that you're going to come up with a perfect solution, or anybody will, is the old admonition, not letting perfect stand in the way of the good. So I urge you to
Can I
pass
ask
the
you
bill.
a
Yes, sorry.
question about your thoughts on, there had been some concern about the impact of this rule on, on building advertisement, where you have the name of the law firm on the building, or swag, what have you. Does the
What does that term mean? Somebody else used swag.
swag,
Pens, water bottles,
and-
umbrellas, like hats,
hoodies.
when law firms give
with
you a
that,
coffee mug that says,
I told you I'm too old for this.
I know, you are.
But by my read, I would think that the introductory phrase of "for the purposes of media advertising" would cover that, so, or would, naming on a building, identification on a building wouldn't be for purposes of media advertising?
Well, there's obviously, somebody else could argue it most certainly is, otherwise you wouldn't want it on the front of your building. That
Well,
would
it may be advertising, but not media advertising.
I concur in that, and again, we're back to the point that was raised, that if you Google, take, for example, my colleague, Mr. Gersten, whose law firm operates under the name of Michigan Auto Law. If you Google that, their whole law firm comes up instantly. You know who's there. I mean, they're not hiding behind anything. The people that are hiding are the ones that are of concern.
The Lion one, the Gold Star one. They wouldn't tell me who they were, I called them. We gotcha. I think we understand. Thank you very much, Mr.
Thank you
Bozeman.
very much. Nice to see all of you. Thank you.
Thank you.
The next item is the item number 5, proposed amendments to Michigan Court Rule 6.425, and our first speaker is Bradley Hall. Mr. Hall.
Morning, Justices. As proposed, this amendment scares me a bit. The overwhelming majority of trial courts in the state and court administrators and clerks and others, I think, would accept a request for counsel that's handed in at sentencing or mailed to the judge's chambers or finds its way to some other room in the courthouse and isn't properly filed with the clerk, as most lawyers understand that term. But there are judges, and I won't name names in this hearing, but there are judges who we see who will deny requests on day 43, or where in the old form it wasn't notarized in the right place, or a piece is missing from the indigency portion, or somebody said during a pre-sentence investigation interview that he's hoping for a big recording contract, and so his ship's going to come in, and well, he's not indigent. So we see these things.
How do we, I think the case that motivated this proposal was one where the defendant had claimed that he handed the form to the bailiff in the courtroom. And the court, of course, has no way of verifying that type of a claim. So the idea was, no, it should be filed, maybe broadened to the request being made on the record. But how do we deal with a situation where it's unverifiable? So then any time a person claims they did it, do we then have to credit that claim? Or, I mean, how do we ever enforce the limitation?
I think that the proposal to require a trial court to accept it if tendered at sentencing would address the problem that apparently prompted this proposal.
So you agree filing would be okay, you have no objection to filing, but you're saying filing or received on the record in open court?
I was prepared to support the Board of Commissioners, the State Bar Board of Commissioners proposal, which adopts the vast majority of what we suggested, but keeps the word filing, because it defines the word filing to include tendered at sentencing, and it should be deemed filed when received by the court, which makes me feel much more comfortable. Last week,
But tendered on the record, right, in open court, not
yes,
tendered after the
not handed
case
to a
is-
bailiff, et cetera. But the absence of that provision today apparently means somebody will hand it to the bailiff on their, as they're being let out of the courtroom, under the assumption it's going to be turned in, and probably it would in 99% of cases, but they come up. But if the court rule requires the trial court to accept it at sentencing, then I think it provides that opportunity on the record rather than forcing it to be handed to a bailiff. What concerns me about the word filed still, even with that additional language that we suggested and the Board of Commissioners endorsed, is, you know, I've seen a draft, I don't think it's official, but I've seen a draft of CC 265, the request form, and what it would look like if the court adopts the word filed, and it tells a defendant, you may request an attorney by completing the request for an appointment of attorney section below and filing it with the trial court within 42 days of sentencing. I mean, it says you file it by sending it here, but I can foresee indigent defendants who are incarcerated in transit, et cetera, saying, I don't know how to file this. I mean, this seems very complicated. To the extent the rules are inconsistent, I think it's appropriate here. I think we want a liberal mechanism to allow indigent, typically incarcerated defendants to request counsel. And I don't think we need to have consistency just because it makes us feel more satisfied. I think the language should remain completed and returned with the additional pieces.
But, so, I think you might lost me at the end. So your objection now is to the draft form?
I mean, this is
that's
something we
supposed to
can take
effectuate the
up,
rule?
this is something we can take up with the forms
With the
people.
Forms Committee?
But
Yeah.
if this court adopts the Board of Commissioners recommendation, okay, we'll change it to filed, but we'll redefine filed.
Right,
That makes me feel much more comfortable.
right.
But, you know, if that language then makes it onto the form and this is how it's communicated to a defendant, that concerns me.
So we have to look at the form, okay.
Yeah, I think so. And I think,
Okay.
I mean, there are other reasons to look at this form as well, as, to direct trial courts that they must accept it at sentencing, et cetera. But in any event, my biggest concern and what prompted me to come is that the court might be inclined to kind of, well, if the Board of Commissioners supports the word filed, we'll go with filed.
Gotcha.
I'm okay with it, but only with the other pieces. I think it's a dangerous road without defining the word filed more liberally.
Thank you.
Thank you.
And next we have Stephen Helton on this same topic.
Good morning. Thank you very much for allowing me the opportunity to comment. My name is Stephen Hilton. I'm an assistant defender with the State Appellate Defender Office. Before that, I was a max roster attorney, and about half of my assignments came out of the Third Circuit. So I would just like to talk to the court a little bit about the likely practical effect of increasing the things that can go wrong when a defendant attempts to request counsel. So on many, many occasions, I have had a client who had their request was deemed submitted late, but it was clear that they had attempted to request counsel within the 42 days. In those situations, I would usually file a motion to reissue the judgment of sentence with the trial court. I know it's also common to file a motion to reinstate the claim of appeal. Generally, where it's clear that the attempt was made to submit it, the people would file a response stating that they neither agree with or oppose the motion, and they'll leave it to the court's discretion. So we have to have a hearing on the motion, and the trial judge is almost always sympathetic to what occurred and will grant the motion. I think in one case, which was a more complicated case than usual, it was denied, but I think only one case I had it denied. So it seems like a rule that increases the number of things that can go wrong will lead to more of these types of motions being filed, which will increase the burden on parties on counsel for both sides, as well as trial court judges, and slow down the merits being reached on an appeal. And it doesn't really appear that that any stakeholder would be benefited by this modification. So I would strongly encourage the court not to adopt the proposed modification. The other thing I just wanted to briefly comment on is the Prosecuting Attorneys Association of Michigan's proposed modification to subsection E1E to omit the requirement that sentencing judges articulate reasons, quote, justifying that specific departure. Whether that language is still applicable and appropriate post-Lockridge and Steenhouse, it's currently before the court in Dixon Bay. And so I don't think it makes sense for the court to modify the rule before it's actually announced where the law stands. And if the court has any questions, I'd be very happy to answer them. But otherwise, thank you very much for your time.
Thank you for being here. We
Thanks.
appreciate it.
Thank you.
And our final item is item number 7, which is a proposed amendment to Michigan Court Rule 3.993, and Judge Angela Sherrigan from the Little River Band of Ottawa Indians is here.
Thank you very much. Good morning. I am actually here on behalf of the State Bar of Michigan today.
Oh, sorry, I identified you the way you were on my sheet. Thank you for being here.
I am here to comment on this rule. This rule proposal originally came to the State Bar of Michigan through the Representative Assembly from the American Indian Law Committee. The American Indian Law Committee, as you are all aware, is an instrument that the Tribal State Federal Judicial Forum uses to put into action the recommendations. The forum was actually a creation of the Michigan Supreme Court, so I'm very happy to be here today. The current court rules do not allow all of the appeals that should be covered as a matter of right under the Indian Child Welfare Act and under the Michigan Indian Family Preservation Act. Specifically under the Indian Child Welfare Act, it is 25 U.S.C. 1914. MIFPA, the Michigan Indian Family Preservation Act, has a very similar provision which allows for appeals for violations of 1911, 1912, and 1913 of the federal code. Unfortunately, what is happening in the Court of Appeals is that these are being treated as discretionary because they are not final orders. The Court of Appeals, in so much as noting this in Ray McCarrick versus Lamoureux, suggested that the Michigan Supreme Court consider modifying MCR 3.993 to expand the permissible appeals directly to the court so that there was no confusion to the Court of Appeals what is a matter of a right of appeal. The comments that had come in written to the Supreme Court Administrator's Office, none of the comments were opposed. The Court of Appeals did actually look at the rule, and they did make a comment saying that they are not taking a position one way or the other, but they are not objecting. The Michigan Judicial Association did weigh in on it also, and they support it. This certainly, if this proposal is adopted, it certainly would clear up the discrepancy between the federal law, the now Michigan law, and the court rules, and allow the appeals that are given as a right under the Indian Child Welfare Act and corresponding Michigan Indian Family Preservation Act. It would help all children in Native communities because the ultimate, I'm losing my word here. The ultimate consequence for a violation of this is that it's invalidated and you start over. If the Court of Appeals is not able to hear these in a timely fashion, what happens is cases drag on for 2 years, and then 2 years later, you're invalidating something that could have been invalidated in the first 45 days. Thank you.
Thank you very much for being here. Thank you all. We appreciate your input. It helps us do our job.